Hi everybody, Jennifer Schaus here. Thanks for joining us in our webinar series for 2025 as we cover the DFARS, or the Defense Federal Acquisition Regulations Supplement. We go through the DFARS for a couple weeks throughout this year, and if you want to sign up for the series, you can find it over on our website. Just go to the section called the DFARS. And on the right-hand side, you can find all of the recordings once we have the recordings, as well as the upcoming webinars to register for. If you're anxious to get to a part that we have yet to cover, you can go back to the historical section on that same page on our website, which will give you the 2021 recordings. Keep in mind that the DFARS, if you've been paying attention for the last couple of weeks, that they do have a heartbeat. It is a living, breathing document, I guess you want to call it, and sometimes the regulations will change. So just keep that in mind if you are looking back at some of the recordings from, again, 2021, which was 4 years ago. Okay, a little bit about us. So we are based in DC and work with established government contractors, providing some of the services that you see here on the screen, with a primary emphasis on GSA schedules, VA schedules, FedLink, which is Library of Congress's contract vehicle, and more. You can find more information about us on our website at jenniferschaus.com. In the event that you are selling to federal contractors, so the banks, the law firms, insurance companies, payroll, and you name it, we do offer advertising in our newsletter as well as in this webinar series. You can even put on your own webinar with us. We put on events and conferences throughout the year. We offer sponsorship opportunities there. And we can post on LinkedIn and other social media sites for you. If you're interested in advertising, again, to federal contractors, drop us an email and we'll send you our media kit, which has pricing information. Here's some of our stats for our newsletter subscribers. It's free to sign up for our newsletter. So we've got almost 37,000 subscribers, most of which are government contractors. Open rates as of this morning were at 28%. Okay, so we want to thank our in-kind sponsors. First are our friends over at Gov Events. That's the premier platform for posting events related to government and government contracting. You can find all of our webinars and our events on govevents.com, as well as our recordings from our past 700 plus webinars. We also want to thank Tom Johnson and his team at Set Aside Alert. That's the go-to publication for contracting opportunities for small, women-owned, veteran-owned, hub-zone, and 8A firms. Visit setasidealert.com for more information. Also, Fairfax County Economic Development Group is a great resource for businesses in Northern Virginia. Please visit their calendar to learn about events and trainings, including this webinar series. We also want to thank the Virginia Apex Accelerator, formerly known as your PTAC or Procurement Technical Assistance Center. They've been rebranded for a while now. They provide training, counseling, and mentoring for aspiring government contractors. The Apex Accelerator also provides matchmaking events. Please visit the links on your screen to review the training calendar, their free resources, and to schedule an appointment with a Virginia Apex Accelerator counselor today. Okay, now we want to thank our corporate sponsors, which is what makes this series complimentary to you. Our friends over at BidSpeed. The BidSpeed platform allows users to search public sector opportunities at the federal, state, and local level. Users can also find teaming partners, incumbent point of contact, expiring contracts. You can also find a compliance matrix and proposal templates. Discover, manage, and secure government contracts with BidSpeed. BidSpeed is an official partner of the SBA's ETG Empower to Grow program. C3, if you are thinking about getting in on contracts with the Department of Defense, you need to prepare for CMMC. C3's suite of CMMC solutions include C3 Command, C3 Catalyst, and C3 Core. These answer the needs of every defense contractor seeking to achieve CMMC compliance. Whether your priority is a fast, defined path to compliance, or you need the flexibility to manage multiple environments. The C3 suite offers compliance solutions. A partner with deep expertise in IT, cybersecurity, and compliance are your best defense against the risk of non-compliance. Contact C3 today to learn more. And I think we'll hear a little bit about CMMZ today. WorkPlan is an online contract management and accounting platform designed for federal contractors and hosted by Amazon Web Services. Get and stay DCAA compliant, manage expenses, timekeeping, and forecasting, plus use the WorkPlan platform to manage capture and CRM. Integrate your HR and payroll systems into this one easy-to-use system. Contact WorkPlan to schedule your demo today. And last but not least, our new friends over at Ataria. Ataria specializes in Microsoft Cloud licenses and services for government and contractors. Your business advantage for Microsoft Government Cloud licensing, managed IT administration and security, and data intelligence services and solutions. They implement secure, compliant, and scalable solutions to enhance your operations, reduce risk, and uncover opportunities. Contact Ataria for expert guidance on your IT roadmap. Okay, we are here today to cover the DFARS Part 204. We've got Pete Dungan over at Miles and Stockbridge who has joined us today. He's got a great slide deck and is going to give an awesome presentation. Pete, thanks so much for joining us today. I'm excited to hear what you've got to say. I'm going to put myself on mute and turn the floor over to you. Just let me know when you're ready for your next slide.
Great. Thank you, Jennifer. Thank you for the opportunity to present to everyone today. I'm Pete Dungan. I'm the co-chair of government contracts and a principal in the law firm of Miles and Stockbridge in our Washington, D.C. office. Miles and Stockbridge is a law firm providing a full range of cradle-to-grave business services to businesses across the country, including government contractors. My contact information is on this slide. If you have any questions, please feel free to reach out. Next slide, please. So today we're going to cover Part 204 of the DFARS, which is titled Administrative and Information Matters. But it really is much more than administrative and information matters. Probably the two most important subjects that we're going to cover today are security and cybersecurity, and supply chain assurance. Security and cybersecurity, you are not going to learn everything you need to know about that today. But what I am going to show you is the regulatory basis for the requirements that apply to defense contractors, so that you can issue spot and be able to ask intelligent questions if you need to reach out. Same thing with supply chain assurance. In particular, we're going to talk about the covered telecommunications rule as it applies to the DFARS. Cage code and SAM information. This is what allows you to bid on contracts and allows you to get paid, as well as cage information is important for your security clearance if that applies to your company. So that is vitally important, and I can tell you war stories about people not getting paid for weeks because of simple information in their SAM entries. So that is a very important topic, even though it might be somewhat boring. And other administrative and information matters that are probably not important until they are. And I'll briefly discuss how they might become important in particular factual situations. We're going to spend most of our time on security and cybersecurity. Next slide, please. Part 204 contains three subparts that really talk to security and cybersecurity. One of them regards classified information, and 2 of them speak to cybersecurity. Next slide, please. Part 204, subpart 204.4 adds to the part 4.4 provisions in the FAR regarding safeguarding classified information. And these should be considered what I would say supplements to the NISPOM regulations. It's important to know these rules as well because they lay on top of those NISPOM regulations that apply to every cleared contractor. Some of these provisions are pro-contractor, and often people in the government don't know about them. And some of them are important for contractors to understand because they provide additional compliance requirements. One important one is that 204.402 prohibits a contractor from requiring a government employee or service member from relinquishing control of classified information at contractor sites. Now that's important because there usually is a requirement in both the NISPOM and many contractors' security procedures to ensure that classified information is not removed from the site. So these provisions have to be read hand in hand because if you're blindly following a checklist, you may run afoul of this rule. But government employees and service members are responsible for the security of any information that they may provide, and this rule prohibits you from requiring them to give up any information that they may be a courier for. Jennifer, I don't know if you've gone over the PGI, but it is on prior webinars, but the PGI is a kind of companion to the DFARS, and what it's supposed to do is provide instructions that are solely for the internal use of the government that may apply to acquisitions. But oftentimes the PGI provides important information that contractors can use to their benefit. PGI 204.403 provides insight into many of the things that a contracting officer will take into consideration for determining whether a contractor has adequate security measures. And so if you're in the award phase or waiting for an award, that can give you important information if there are any concerns that the CO has expressed. Reading that can give you insight into what the CO may be concerned about. And it prescribes the DFARS clause 252.204.7000. When exercised and included in a contract, that clause completely restricts the disclosure of unclassified information without approval. Now, that clause, when utilized, goes far beyond the cybersecurity rule, which only governs covered defense information. 252.204.7000 goes a step beyond and restricts disclosure of any unclassified information that's been identified without approval. That's an important one. It only applies in certain types of contracts. So if you see it in a solicitation, you may be able to fight it and convince the CO that it shouldn't be included, because it places a compliance burden that may be far beyond what you're used Next slide, please. Okay. Subpart 204.73 is the regulatory basis for the DFARS cybersecurity rule, which has been in place since 2017, or been effective since 2017. And it provides important definitions for controlled unclassified information, controlled defense information, covered contractor information system, which is a trigger for the compliance requirements. All of those definitions should be committed to memory by personnel in your organization that are charged with government contract compliance and with IT security. Oftentimes we'll run into clients who say, well, I don't have any CDI, I don't have any CUI, so I don't have a covered contractor information system. And oftentimes we find out that they're wrong because they either misunderstand the definitions or those personnel are insulated from the facts or the ground truth about what the company is actually receiving from their government customer. So those are important definitions for people who the rule applies to know. They're probably more important definitions for people who think that that they're not covered because they may have to defend the fact that they're not covered by this rule. It describes, this part prescribes the DFARS cybersecurity clause, 252.204.7012. That has two major requirements. If you are a contractor that has a covered contractor information system, it requires compliance with NIST SP, Special Publication 800-171 for covered contractors. I'm not going to go into detail about what that publication requires, but generally it requires the implementation of 110 security controls that are often very burdensome and require oftentimes outside assistance to help implementing them. The clause also generally requires the immediate reporting of cyber incidents. The cyber incident has its own definition in the clause. So it's a term of art, and it may not comport with the way that phrase is defined under other reporting regimes, such as state privacy laws. If there is a breach or some kind of compromise of your system, you need to do separate analyses with regard to any state law requirements that you may have, any Privacy Act or HIPAA requirements you may have, and compliance with the DFARS cybersecurity rule. It also prescribes DFARS 252.204.7019 and 252.204.7020. These clauses, when read together, have two main requirements. First of all, it requires the contractor to execute either a basic self-assessment of its cybersecurity using the template that's provided, or alternatively, if you've been identified by the government for a medium or high assessment, which is government run, that you make yourself available and submit to those assessments. The second main requirement is that once either the self-assessment or the medium or high assessment is completed, your score, along with the completion date of your plan of action and metrics, must be entered into SPRS. I'll talk about SPRS later on in the presentation, but it requires the reporting of those scores and the completion dates. Your POEM is your plan of action and metrics, which NIST SP 800-171 requires you to generate if all 110 controls are not implemented. And that plan of action and milestones will document when full compliance with NIST SB 800-171 is projected. Finally, the subpart tells contracting officers that award is not supposed to be made until the contracting officer verifies that a score has been entered into SPRS. Now, I happen to know through personal experience that this check is often not done by DoD contracting officers, but it is done sometimes, and the CO definitely has the authority to do that. And I have also seen situations where an award is not made because a score cannot be identified. But I do recognize the fact that these checks are not happening with the frequency that the DFARS says they should be happening. So that's the DFARS cybersecurity rule, the current one in a nutshell. Obviously, mastery of that is could dictate its own class or own set of classes, but this will at least tell you, point you to the regulatory basis for it, and allow you to issue SPA. Next slide, please. Subpart 204.75 is the basis for the Cybersecurity Maturity Model Certification Rule, which was the final rule was implemented on December 16th, 2024. When fully effective, the intent of the CMMC final rule is to replace the DFARS cybersecurity rule, the safeguarding unclassified information rule, which is a self-certification model, with a third-party certification model, where authorized C3PAO certifiers authorized by the Department of Defense certifying authority will audit, review contractor cybersecurity procedures and controls and certify that the contractor meets a certain level. There's currently a 9-month implementation period, as solicitations and contracts are not supposed to contain CMMC requirements until October 1st, 2025. If the rule remains in place, and this rule has been subject to many extensions, so it could be extended, but as it's currently written, beginning in October 1st, 2025, all solicitations, contracts, and orders will contain the CMMC clause, except contracts and orders that are solely for COTS items. And I stress solely for COTS items. If you have a contract that has some COTS items and some, say, just commercial items, or what's called now commercial products and services, that will be subject to the DFARS cybersecurity rule. What is never a COTS item? Well, that's usually a commercial service, right? So the deduction is pretty much all service contractors, no matter what the service that they're providing, are going to need some level of CMME certification. It could be a relatively non-burdensome certification like level 1, where just basic safeguards need to be put in place in your IT system. But you will need that certification nonetheless. CMMC involves 3 successive layers of cyber requirements. There's level 1, like I discussed. Level 2, which is pretty much the implementation of NIST SB 800-171 but there are some additional requirements. And then there's level 3, which is essentially demonstrating that you have the ability to handle a classified IT system. The Department of Defense predicts that most defense contractors will need a level 2 certification. Again, CMMC is kind of a subject all on its own. If you supply goods and services to the Department of Defense, you need to take a hard look at this. You need to, if you haven't started the ball rolling with getting a CMMC review and certification, you need to do that. And there are resources out there. You can reach out to Jennifer or to me, and we can point you in the right direction of consultants that can help get you compliant and certifiers. Next slide, please. The next subject that I've grouped a couple things in is supply chain assurance. And this reflects a growing trend in the Department of Defense to ensure that the supply chain is coming from trusted sources, and that our adversaries are not introducing flaws into our supply chain. Next slide, please. The first subpart on this is regarding the telecommunications, the covered telecommunications and video surveillance services ban. Okay. Now, this is somewhat duplicative of the ban that you may already be aware of in FAR.42102A and DFAR and FAR 52204-25. That is a representation that all contractors have to make when they register in SAM.gov, that they either do or do not supply or use covered equipment. But this provides a little bit of a twist on it, in that it specifically prohibits award of a contract or order or extension, renewal or exercise of an option to procure any item where covered equipment, which is a defined term that you need to know, is a substantial component or where covered equipment is used as critical technology. Okay, and covered equipment includes certain telecommunications equipment and video surveillance services from specified companies that have ties to the Chinese government. And those are listed in the rule. FAR 4.2102 and FAR 52204-25 tend to be more stringent than the DFARS rule, because it's not limited to the award of a contract, order, or extension, renewal, or exercise of an option, but prohibits any expenditure of appropriated funds if the company supplies equipment from these companies. It also prohibits use internally of covered telecommunications and video surveillance services. So those are more stringent than the DFARS rule. The FAR rule also requires a, quote, reasonable inquiry, end quote, prior to representing in SAM.gov, or when asked to a government agency that you either do not use or supply covered equipment. So you need to understand both the FAR rule and the DFARS rule. The FAR rule is generally going to be more stringent. and the one you need to worry more about. Next slide, please. Okay, the supplier performance risk system. In studying for this presentation, you know, I knew that SPRS had some information in it, but I was kind of, my eyes were open as to how much information the SPRS has in it. And it really has a lot of information that could affect your ability to get additional work. It requires the contracting officer to consider supplier risk assessments that are contained in SPRS in all procurements unless exempted in DODI 5000.79. And in reading DODI 5079, one finds that the instruction does not apply to cryptographic procurements, healthcare procurements, or the procurement of fossil fuels on a bulk basis by DLI. Which would mean that the rule would apply to all other defense procurements by logical extension. Are these risk assessments happening in all defense procurements? Probably not, but the DFARS says that they're supposed to happen. And it requires the contracting officer to consider supplier risk, price risk, and item risk when that information is available in SPRS. It specifically states that price risk in SPRS is a separate consideration from the fair and reasonable price analysis that a contracting officer must do whenever they award any contract. I found that very interesting, that there's this kind of separate analysis that's supposed to be going on. Supplier risk includes, but is not limited to, the information that a contractor self-provides when they do the cybersecurity score and POAM date input into SPIRS that they're supposed to do. It prescribes the use of DFARS 252-204-7024, which is the notice of SPRS information. It's supposed to be in all solicitations, including commercial items, except those that are exempted, which we discussed previously. The bottom line is that SPRS risk ratings can impact your ability to get contracts. So if you become aware from a contracting officer or contracting personnel that the government has some adverse information about your company that may be inaccurate, you may want to dispute that information. You may want to rebut that. You may want to consult with legal counsel on how you might be able to rebut that, because it could have an impact on your ability to win business. Next slide, please. Cage code and SAM registration. These are important because the SAM registration is required to contract with the government. Many prime contractors require it so that they can review your representations. And for prime contracting, it's how you get paid. You have to input your bank account information into SAM registration. So it's critically important, and when you have a hiccup with SAM registration, it can affect your bottom line very quickly. The same goes with cage code. Cage codes and SAM registrations have a symbiotic relationship. When you make a change to one, the cage office at DLA is notified. And so the cage office can basically give a veto power as to whether your SAM registration renewal or your changed information goes through. And there's a problem again, that can hiccup your ability to get new awards or the ability to get paid. So this is very important, even though it may read very dry in the regulation. And again, as with most DFARS parts, these add on top of the corresponding parts in the FAR. Next slide, please. Okay, so the interesting thing about the cage code regulation in the DFARS is it mainly just points the reader to PGI 204.1870. Now, you may remember us discussing the PGI in that it's supposed to provide internal guidance to government acquisition officials and not supposed to affect the rights of contractors. But if you read the PGI, it contains a lot of information that appears to affect the rights of contractors. I found it very interesting in PGI 204.1870-1 is there's a lot of pro-contractor information in there. It requires COs to assist offerers in obtaining cage codes. It requires COs to produce solicitations to interested parties, even if they do not yet have cage codes. It specifically states that DoD contracting officers shall not require contractors to register in portions of SAM that are not required by a contract or solicitation clause. Now, I can think of situations in which clients have run into problems with all three of these things. So if you know that this information is in PGI, you can point this out to contract officers by saying, listen, I'm trying my best to get my cage code, but we'd like your assistance. And please don't try to block us from knowing about an opportunity simply because we don't have it in place yet. The next provision of the PGI provides insight into how DLA should administer the cage code. And in reviewing that and comparing it to my personal experience with DLA Cage Code Office, there appears to be discrepancies in how the DLA office often administers the cage code. So if you run into problems with DLA and they're holding up your cage code because of unreasonable demands, it may make sense to review that provision and see how it might differ from how DLA is behaving in your particular situation. Next slide. Okay, subpart 204.11 supplements the system for award management. It states that COs must use the contractor's legal name and physical address recorded in SAM as of the time of award to complete an award document. Sometimes contractor may want a different address or may want a different doing business as name on it. And what this regulation states is no, the CO can only use what's in SAM. So it's very important that you keep your information in SAM accurate and that you make any changes that need to be made before an important award to have those changes made plenty of time to account for hiccups and problems that the government may have in processing those changes. COs must verify that prior to exercising an option or issuing a modification that the SAM record is active and the document matches SAM. So that record must continually be updated. Remember, SAM is your hunting license. You have to act early and proactively to keep it active. Waiting until the last minute to update information is not a good idea. Next slide, please. All right, finally, we'll cover the other administrative and information matters. We're not going to go through each and every subpart, but I will highlight the ones that I thought are important to know. Next slide, please. Subpart 204.17 governs service contracts inventory, which was put in place by a NDAA iteration several fiscal years ago. It requires certain service contractors to report in SAM.gov the total dollar amount invoiced for services and the number of direct labor hours per year. In those statistics, you must include first-tier subcontractors. So if a prime contractor is asking for that information, this is the basis for them asking. If you're a prime contractor, you need to remember that if this provision applies to you, you have to negotiate in your subcontracts, this reporting requirement. Subpart 204.71, the Uniform Contract Line Item Numbering System. It includes a lot of useful information that I think are often important when we think about various issues that my clients, your company, may have in contract interpretation, such as it includes definition procedures for what is a severable or non-severable service. Well, why does that matter? Well, one fact pattern is in a government shutdown, oftentimes the DoD will say a severable service has to be stopped because you need a new fiscal year's money to put on the contract. But a non-severable service for money that may apply over several fiscal years does not have to stop. So it's important to know whether your services are severable versus non-severable. And this subpart provides information. It governs how accounting classifications are applied to the contract. Has a contracting officer ever told you we're out of money? Well, that may or may not be true. And it's not that the contracting officer is lying, but the CO may be misinformed. The agency may, in fact, not be out of money. And what's going to govern that is what pot of money that contract is funded out of, and that's going to relate to the accounting classification. The unit of issue. Oftentimes these are disregarded in the schedule of a contract, but those have meaning. Each versus lot versus another type of unit of issue is going to be very important in determining how the contract is billed, what happens in a termination, etc. So very useful information that you may need to dust off if there's some kind of contract interpretation dispute with the customer. Finally, subpart 204.74 governs disclosure of information to litigation support contractors. If you are a litigation support contractor to the government, you have certain increased information security procedures. If you're just a regular contractor, that provides notice to you that in certain circumstances, if you have a dispute with the government, they are going to give that information to their litigation support contractors to help them resolve the dispute. Next slide, please. That concludes the presentation. Again, this is not a complete rundown of every rule in the subpart, but it's the ones that most often come up. And if you take nothing away from this, just know that you need to really understand the cybersecurity and CMMC rules. If they apply to you, you need to understand them. If you think they don't apply to them, you really need to understand them, because you may have to defend the fact that you think it doesn't apply to you. Jennifer, again, thank you very much for the opportunity.
Yeah, great presentation, Pete. I like how you had it organized. It was very clear. I'm glad that you touched on PGI as well in the earlier slides. We did briefly discuss it in the earlier presentations last week, but I'm glad again that you brought it up. And everybody, if you've got questions about today's DFARS presentation, please contact Pete. You've got his contact information here. If you're watching this on YouTube, give us a like, leave a comment. We would love to hear from you. If you're looking again for the recordings from the earlier presentations, you can find them on our YouTube channel. It does not cost you anything, and there's 740 plus government contracting webinars there, all for free. The slides are over on slideshare.net, and you can just log in there with your LinkedIn credentials. Again, that one does not cost you anything. We want to thank our sponsors and everybody who's attended the live presentation. You can join us on Friday as we cover DFARS Part 205. Again, thanks, Pete. Thanks to all our attendees. And we'll get the recording out within about 24 hours, probably less.